in the appeal, Wood and Capita Insurance Services Limited.
May it please the Court, I appear for the appellant, Capita Insurance Services Limited. My learned friend, Mr. Twigger QC, is the respondent, Mr. Wood. As your lordships will be aware, this appeal concerns a short point of contractual interpretation regarding a particular clause in a share purchase agreement that I'll refer to in my submissions as the SPA, for, I hope, obvious reasons. I plan to structure my submissions.
I think the reasons are obvious. Yep.
I'm grateful, my lord. We may have to come back to how obvious they need to be a bit later. I plan to structure my submissions as follows. First, to address the law, and in so doing, to highlight what in my submission was the fundamental mistake that infected the whole of the Court of Appeal's approach. Secondly, I plan to examine the context in which the SPA was agreed, the SPA itself, and the contentious clause itself. Third, I propose to address the points of language, grammar, punctuation, and syntax that support the appellant's interpretation. And then finally, I propose to address the ways in which, in my submission, the commercial context in which the SPA was agreed, and the commercial purpose of the contentious clause, as assessed objectively from the rest of the contract and the background facts, also assist in determining the true interpretation of the clause.
That's a very helpful summary. On the first point, I think the one thing that we would not encourage is any sort of lengthy analysis of the law or of what the Court of Appeal, you say, thought the law was, because this being a point of construction, in the end we're going to consider it for ourselves. And taking us to authorities that we all know very well and have looked at is not going to be very profitable. We all know what the basic principles are.
I understand, my lord.
Or think we know, anyway.
I understand, my lord.
We don't think there's any inconsistency, and I understand it. Neither of you suggest that there is, although you do suggest that the other side suggests that there is, inconsistency between recent decisions, including Rainy Sky and Arnold and Britton. So perhaps we can just concentrate on, in the end, what seems to us ultimately to be a one-off point of construction, namely what this provision means in this contract.
I'm very grateful, my lord, and I had noted...
In its context, I
had noted that your lordship had expressed similar views about Arnold and Britton in November 2015 when speaking to the Residential Property Tribunal Service.
You've obviously done quite a lot of research.
What I may do is just briefly trespass on Arnold and Britton and what I say the scope of it should be. But if I am trying your lordship's patience in so doing, then I'm sure I'll receive...
No, well, we understand the point. The use of Arnold and Britton is a case where the words only had one meaning, effectively, and to depart from the words was inappropriate. Whereas in Rainy Sky, there were two possible meanings, and that was different. We have all that.
Your lordship has it. And let me just sum it up now, then. The points that your lordship emphasised in that case are points which, in my submission, are particularly salient in circumstances where the words of a clause only have one meaning.
Yeah, I've just said that.
And don't apply in the same way in a case here where there are two meanings.
Thank you.
Just to briefly summarise then...
Once one has decided which of those meanings is preferable as a matter of language, then there is only one meaning left.
Not all of us would agree with that proposition.
My Lord Mance has preempted what my submission was going to be. That presupposes that one can give words meaning absent an analysis of the context in which they appear. And therein is the devil in the detail, and that's probably a good reason why I should move on as promptly as possible to the terms of the particular clause here.
Okay, well, every possibility is before us then.
But you can always go back to the principles if it appears that there is a vital point of distinction. But I think if we focus on this clause, that is probably, in its context, that is probably the better way to proceed.
I'm very grateful, my lord. Well, without further ado then...
It's even difficult to talk about meaning of words here. It's more a question of jigsaw, or which order you put the dominoes and which connects to which.
Exactly, my lord.
Whether you put two down at the same time or them down individually.
Exactly. And one point I will make in that regard right at the outset is it's dangerous, potentially, to look at passing aids that put ones and twos that aren't there in and A's and B's that aren't there in different places. And there can be no substitute in my submission for looking at the clause in the context, physical context in which it appears in the actual SPA itself.
Very well.
Turning then, before I go to the clause itself and the SPA itself, to the background in which the SPA was executed. It's common ground that at the time of the SPA, all of the parties were sophisticated commercial persons with experience of the insurance broking industry. It's also common ground that each of Capita, as the purchaser, and the company whose shares were being purchased, Short Term Direct Limited, were regulated by the FSA and were therefore obliged to comply with its rules as promulgated from time to time. In that regard, in my submission, it's particularly important to understand the way in which the FSA's regulation and financial services regulation works. Specifically, the FSA, as the FCA continues to do, took an interventionist and active approach to regulation. Now, I would illustrate this, if I may, by reference to the further particulars that Capita served in these proceedings, to which, insofar as I'm going to refer to them, my learned friend hasn't taken objection.
Right.
They are in the main appeal bundle,
Yep.
tab F,
Yep.
tab 8, and that's MS 146. No, I'm wrong. They're tab 9, and that's MS 165.
Yep. Yep.
I'd ask your lordship simply to read paragraphs 1 and 2 initially, please.
Yep.
And I'd also ask your lordships to read at paragraph 3
Yep.
what some of the salient principles were.
Yep.
And I would emphasise, if I may, in particular, Principle 5 at paragraph 3.3, a firm must observe proper standards of market conduct. Principle
Right.
6 at 3.4, a firm must pay due regard to the interests of its customers and treat them fairly. And Principle 11 at 3.6, a firm must deal with its regulators in an open and cooperative way and must disclose to the appropriate regulator, appropriately, anything relating to the firm of which that regulator would reasonably expect notice.
I mean, your point is that the FSA doesn't wait for complaints to come in.
That's one of my points, my lord. And the other point is, it not only doesn't wait for complaints to come in, but it's incumbent on regulated entities to self-report effectively and to engage in a cooperative way with them.
And there are spot checks on a more or less random basis.
Indeed, my lord. And one sees an example of that. I wasn't going to go to it because it is more contentious because it goes to the facts of this case. But one sees an example at 8.1 and 8.2 on the next page of a spot check, an arrow visit it's called, an advanced risk-responsive operating framework visit. I think the W comes from the work of framework. And that illustrates exactly the point that my Lord Sumption makes.
Right.
I would also just ask your lordships to read paragraphs 5 and 6, the reference to the new approach, or the beefed-up approach, that Hector Sants, the then chief executive of the FSA, announced on the 12th of March 2009. That was a year before the SPA, in this case, was entered into.
Okay.
It's apparent from this in my submission that there's no magic or particular significance in there being a claim or complaint made to or registered with the FSA or any other regulatory body. The FSA was poised to intervene when it was appropriate to do so, and regulated entities, as I've just explained, had to self-report and had to engage with the FSA in an open way. At the same time, as regardless of FSA involvement, treating their customers fairly.
Right.
One can see this from the imposition of national schemes that I'm sure your lordships are all aware of for PPI mis-selling and for interest rate hedging product mis-selling, whereby they were imposed by the FSA after their own investigations and in conjunction with the firms who had allegedly been mis-selling, or had been mis-selling, but had allegedly been engaging in wide-ranging mis-selling. The other significant aspect of the context in which the SPA was concluded is that prior to the takeover, the sellers were both directors of the company, all the directors of the company, and were 100% shareholders of the company. And we'll see in a moment when we go to look at the terms of the SPA that Capita's purchase of any of the shares was conditional in effect of purchasing all the shares at the same time. So it was a complete takeover. And prior to the takeover, the sellers had complete control of the company.
Okay.
That meant that they were in a position to direct, to influence, and to find out about both the way the company could conduct its business before the SPA and the takeover, and also the extent to which the company had been complying with FSA rules, and the extent to which its general business was compliant with FSA rules. Capita, on the other hand, as the purchaser, was in no such position. There's never been any suggestion that it had been involved in or had any real knowledge of the company's compliance with FSA rules prior to takeover. So the sellers were perfectly placed to know about and to assess the risks of mis-selling, and the buyer was particularly ill-placed.
Yeah.
That's all I intended to say at this stage, at least, about the background.
Thank you.
The SPA itself appears in the core bundle at tab 11 from MS 182.
Yes.
One sees from that page that it's dated the 13th of April 2010. It's stated to be an agreement between the tramlines for the sale and purchase of the entire issued share capital of Short-Term Direct Limited. And the parties are, on the one hand, the three sellers, each of whom was a party to these proceedings until a compromise was reached between Capita and Messrs. Kitely and Collinge, and on the other, the appellant.
Yep.
Turning over to MS 184, there is, as one might expect, a long list of definitions.
Yep.
The first one I'd ask your lordships to read is the fourth down under paragraph 1.1, applicable financial services laws.
Right. Yes. Okay.
What I'd emphasise there is that that's a particularly wide-ranging definition of applicable financial services laws. And in the preamble, or the beginning of the definition, they are said to be all financial services laws and regulations in the UK to which the company is subject. At the foot of the page, then, authority is defined and given a similarly wide-ranging definition, which I'd invite your lordships just to read.
Yep.
Then overleaf on 185, the fourth full definition down is the definition of the buyer's group. The buyer, any subsidiary of the buyer, any holding company of the buyer, and any subsidiary of any holding company of the buyer. So that's a very broad definition, again, given to what the buyer's group means, anyone in the Capita group.
Yeah.
Relevant person, company is then defined as short-term direct, but that's probably uncontroversial.
Yep.
And then below that, completion means completion of the sale and purchase of the shares, which are all the shares in the company in accordance with this agreement.
Yeah.
Then, on page 188 is the definition of relevant person. And your lordships will recall relevant person features in the contentious language of clause 7.11.
Yes.
And again, that's a very wide-ranging definition. It means any employee or any former employee of the company and any dependent of any employee or former employee of the company.
Yes.
Then overleaf on 189, there's the definition of warranties, which means the tax warranties, and the warranties set out in Schedule 4. It's probably convenient, and I hope I can take this relatively quickly, to introduce your lordships to the warranties at this juncture. They appear from MS 208, and they run on for some 29 pages to MS 237. Now, I don't plan to grind through all of them, but I do make the point, and I'll illustrate this in a moment by reference to the headings. They're very wide-ranging warranties, as one might expect in a share purchase agreement for a company such as Short-Term Direct. The headings are the company's accounts and management accounts. Then there's a section that refers to the company's finance, borrowings and liability. Then the company's business, trading and disposals in section 3. The company's insurance broking business. And then move on to the company's assets at 5. Company's employees at 6. Company's pension arrangements at 7. Company's IT at 8. IP at 9. Property matters and interests in land at 10. Environmental matters at 11. Then at 12, one has litigation, disputes, and investigations. And I will just dip briefly into the specific provisions here and ask your lordships to read 12.4 and 12.5.
What page is that?
That is MS 230 and MS 231, my lord.
Thank you. Okay. Right.
And again, I say they're very wide-ranging.
I understand.
Insurance is addressed at 13, and then at 14 is compliance and regulatory. Now, I don't plan to grind through these, but I would, perhaps for your Lordship's notes, make a particular reference to the following parts: 14.1 A to C, then 14.2 D, E, F, G, I, J, M, O, and P. And then 14.6, 14.7, and 14.9. Finally, 14.11.
7, 9, and 11.
Yes, 14.6, 14.7, 14.9, and 14.11.
7, 9, 11. Okay.
Now, in my submission, and I will come back to this later on, those are very wide-ranging protections against there having been any regulatory problems, to put it colloquially, and also mis-selling prior to the purchase of the company.
Well, 14.1a would cover everything about which complaint is made in the present case.
Indeed, my Lord.
So
Indeed, my Lord.
what's the problem with it? A time limit problem?
There's a time limit problem, which I was going to flag up in a moment. One can see from the beginning of Schedule 5, which begins on page 238.
Yep.
Well, while we're here, I'll flag up paragraph 1.1 of Schedule 5 to begin with. So page 238,
Yep.
1.1. The aggregate maximum liability of the sellers in respect of all claims under this agreement will not exceed the purchase price. So the sellers didn't stand, even under clause 711, they don't stand to lose more than they were paid. And then one sees at paragraph 3 on the same page, time limits, save in respect of a warranty claim or a claim under the tax notified in writing to the sellers prior to such date, the sellers will cease to be liable for any other, this is at B, for any other warranty claim on the second anniversary of completion.
Yes.
The reason I draw attention to the breadth of the warranties in Part 14 of Schedule 4 is that that signifies the allocation of risk that was inherent in the scheme of this contract. It was focused on allocating the risk of mis-selling away from the buyer, Capita, that had no real way of knowing what mis-selling had been going on before it took over because it wasn't involved in the company, to the sellers who had every opportunity to know about it.
But the risk was limited by the time limit of 2 years, whereas on your submission, the same risk effectively is covered without a time limit by 711.
Indeed, and that's exactly the purpose in my submission of 711.
Yes.
It was consistent with what I say is the general allocation of risk. It was to extend that out for mis-selling because of the particular circumstances in which mis-selling arises and the consequences that obviously flow from it. If I may go back then to the main provisions of...
An extraordinary way of going about it, though. I mean, obviously that's the way they did go about it, but you don't, on the face of it, take out of the time limit certain types of claim. You have a separate undertaking, which...
Indeed, my Lord. I may say, it may be something of a jury point, that perhaps shows the importance that was placed on this issue by one of the parties. But again, that's the importance of one of the parties, and it only goes so far. If I may then go back to the operative provisions of the contract, which begin on page 190. One sees there at paragraph clause 3.1, which I'll ask your lordships to read the agreement for the sale.
Yes.
And if I could at this point direct your lordships to page 192 and clause 6.4 there, that makes it clear the buyer is not obliged to complete the purchase of any of the shares unless the purchase of all shares is completed simultaneously. It's the point that I made without reference to the terms of the SPA a moment ago.
That's 648, yeah.
648, yes.
Thank you.
Then back to 191, one sees at clause 4.1 the consideration for the sale of the shares, the initial consideration of nearly £7.7 million, and then the deferred consideration at 4.1b, which could be up to £1.5 million. And for your lordship's note, you see that from MS 269. That brings us on then to part 7 of the SPA, which is the crucial part, warranties and indemnities. 7.1, your lordships will see that each of the sellers severally warrants for his own account and on a proportionate basis to the buyer in the terms of the warranties. Then I'd ask your lordships to read 7.2, 7.4 and 7.5, which again in my submission go to the breadth of the protection that was intended for the buyer under the SPA.
Two, four, and
7.2, 7.4 and 7.5 on page 190.
yeah. Thank you. Yep.
Then before I go to 7.7 to 7.10, in my submission have no bearing on the issue that your lordships have to decide. But before I go to the key clause 7.11, if I could just draw your lordship's attention to 7.12, which is another indemnity, albeit it contains a handful of similar words to 7.11 at the beginning of 7.12b. In my submission, it's not of any real assistance because the two clauses, 7.12 and 7.11, are very different.
Right, so we're just looking at it as background.
I highlight it so that your lordships are aware there was another indemnity that followed at 7.12.
Okay, but then we come back to the crucial 7.11.
Just before we do, and just to complete my tour through the SPA, if I may crave a little indulgence.
No, of course.
Clause 8, there is the reference in the operative terms of the provision. I shouldn't call them operative terms, actually, in the main terms, as it's stated that the warranties and the other schedules are part of the agreement.
Yes.
But at clause 8, it says the liability of the sellers under the warranties is limited by the limitations set out in Schedule 5.
Yes.
But we're not concerned with the warranties, we're concerned with clause 7.11, which appears here. On page 194, the sellers undertake to pay to the buyer an amount equal to the amount which would be required to indemnify the buyer and each member of the buyer's group against all actions, proceedings, losses, claims, damages, costs, charges, expenses, and liabilities suffered or incurred, and then there's a comma, and it says and, all fines, compensation, or remedial action or payments imposed on or required to be made by the company following and arising out of claims or complaints registered with the FSA, the Financial Services Ombudsman, or any other authority against the company, the sellers, or any relevant person, and which relate to the period prior to the completion date pertaining to any mis-selling or suspected mis-selling of any insurance or insurance-related product or service.
Yeah.
Now, your lordships would have seen, on my submission, there's effectively two limbs to which the words that begin halfway through the pre-penultimate line, which relate to the period prior to the completion date pertaining to any mis-selling or suspected mis-selling of any insurance or insurance-related product or service, attach. My learned friend says that there should be a break inserted, even though in my submission it's not obvious there should be one, before the words in the fifth line, following and arising out of claims or complaints registered with the FSA, the Financial Services Ombudsman, or any other authority against the company. Now, if I may highlight to your lordships, I'm sure your lordships are aware of this already, I set out on the third page of my written case the two competing constructions. That's at page 33, behind tab D of the main bundle.
Yeah, I mean, your reliance on the comma is weakened by the fact that there's no comma after the end of your second bullet point.
I agree it would be strengthened, my lord, if there were a comma there.
That's the other way of looking at it.
But I make up for it, if I may put it like that, because of the words and which.
I understand that.
And I say there are two pauses, effectively, when one reads the clause. One of them is the comma that appears before the and at the end of my first bullet point, and the other is and which comes before everything that follows. And what the and which is designed to do in my submission is to show that what follows it applies compendiously to everything that went before, whereas what's in the two limbs doesn't apply to each other.
Yeah, following and arising, I mean, you put the notional comma in, but you say on a respondent's case they might be better phrased if it said which follow and arise.
Exactly, my lord. Yeah. Or rather, and which follow and arise out of, and then you use present participles afterwards.
Well, I think then the second and which would relate to the first and which, and it would be difficult to detach them both from everything that went before.
Indeed, my lord.
But whereas when it simply says following and arising, you say that naturally attaches, especially as it's the same sort of order of things as would be expected to fines, compensation, etc.
Exactly, my lord.
Yeah.
My learned friend conceded below that there was something of a pause denoted by that and which, and I say that there is. It denotes a change in sense of the clause.
Yes, but that doesn't actually help on the point, does it? Yep, okay. You say it does because it identifies that what goes before is two categories, whereas on his case, the two categories have gone earlier.
Exactly, my lord. And if one looks down at paragraph 7 of my written case on page 33, one sees what is in my submission a more complex and strained way of parsing the clause.
Well, you put in each case in brackets to help your argument, but no doubt it could be said against you that on your case, after and which, you would have to add in each case. It's an equally valid addition of in each case, isn't it?
In my submission, not, my lord, because one needs to add it twice here to make it clear that following and arising breaks away from the bullet point that precedes it.
No, but my point really is that you don't need the words in each case. Once you've divided into 1 and 2, it follows.
One may not need them, but they help an appreciation of what is said.
Do you accept that all fines, every case which fell within the words all fines, compensation or remedial action or payments imposed on or required to be made by the company, etc., all cases within those words would also be within the words all actions, proceedings, losses, claims, damages, costs, charges, expenses and liabilities suffered or incurred?
I hope your lordship won't think I'm squirreling away from answering that if I say I'm pretty sure that encompasses everything. I struggle to think what it doesn't encompass. My learned friend hasn't been able to come up with something, and I make no criticism of that, because I haven't been able to come up with anything either. So I think that's very likely.
Well, on that footing, what would be the point of the limitation applying only to all fines, compensation, etc., if it could invariably be circumvented because they would all come within all actions, proceedings, losses, etc.?
I can respond to that in two ways, my lord. The first is your lordship's reading it as a limitation. And that links into my second point, which is...
I thought it was a common ground it was a limitation, but the dispute was about what it was a limitation of.
I don't describe it as a limitation, my lord.
No.
I describe it as part, both... If I may go to the parsing edition, it's probably easiest, the parsing version in the Court of Appeals judgment at page 90, behind tab F2.
Yes.
I don't particularly, it's at paragraph 17 on page 90, I don't particularly like this as an aid to understanding the clause, but it does help in talking about the clause, because your lordships will see there's part 1, part 2, part A and part B.
Yes.
And what my learned friend says is that A and B are two sets of conditions or limitations that limit everything that goes before. I say that 2 and A should be read together as part of a compendious description for the avoidance of doubt of what is covered by limb 1. And so I don't say that following and arising out of is meant to be some sort of limitation on the scope of the clause. Rather, it's aiding an understanding, which the draftsman wanted to include, of certain things which, for the avoidance of doubt, are being included in the clause. And the reason that feeds into one of my strongest points in my submission on the linguistic analysis, and that is that there is a regulatory flavour about all of the items that are included in part 2. Fines, compensation, remedial action, remedial payments imposed on or required to be made by the company. And what's distinctive about Part A is also that it's focused in my submission on regulatory matters. Claims or complaints registered with the FSA, the Financial Services Ombudsman, or any other authority against the company, the sellers, or any relevant person. And that provides a reason, a substantive reason, for reading Parts 2 and A together. And it helps one see that they are intended to be this compendious description.
Yeah, you say it's a continuous process of thought, 2 and A, in relation to a specific area. And I think it can also be said in your favour that it's difficult to see what the point of 2 would be if A relates to 1, because if A relates to 1, you've already got that process of thought relating to the Financial Service Ombudsman and claims and complaints. Have you?
Exactly.
I mean, against you, it would be said, if it's a continuous process of thought, why was it limited to fines, compensation which followed or arose out of claims or complaints registered? Why wasn't it directed to what you say was the background from a year before, that there might be spontaneous interventions by the FSA, etc.?
First, it would have been better from both my perspective and my learned friend's perspective if the clause had been clearer. I concede that. But to answer directly your point, one can see that there might be a particular argument over whether, if a claimant's gone along and made a claim or registered a claim with the Ombudsman, that's something that would be captured by a broad description of the clause. I can't put it any higher than that, really, my lord. It is the clarification they've sought to put in, and it reads more naturally in my submission as a clarification.
Tell me, just to go back, so, do you put a notional bracket after the word claims and after the word authority in A? So, in other words, claims are freestanding, are they? It's claims against the company, the sellers, or any relevant person. They aren't linked to the FSA or...
In my submission, not. I think it should all be read together. My learned friend does put...
Oh, I see. So you think, you suggest that claims, what, claims registered with the FSA against the company?
It's
a bit odd, isn't it?
It is a bit odd, my lord, but so are complaints registered with the FSA. There's no registering process.
Yes, I see, yes.
And similarly, registered with any other authority. It's not what one does. It's an unfortunately worded part of the clause. But my submission simply is it more naturally reads as part of this compendious description that's been somewhat inartfully included.
So the process of thought is, here we are, making absolutely clear that FSA complaints or claims to through the FSA are covered. And the problem is that it doesn't cover other FSA and Ombudsman intervention.
Exactly, my lord.
Yeah.
Exactly, my lord. The other point I make from a linguistic perspective is that somewhat, well, just before I move on, I was going to make this point before I ran to the passing aid. If I could take your lordships back to page 33 in the third page of my written case.
Yes.
And it might be thought a small point, but I just wish it to be made clear. If one looks at paragraph 7 and how the Court of Appeal and my learned friend have passed the clause, they introduce a comma after the word claims that my Lord Mance was just asking me about. Page 33, my lord.
Yeah, yes.
I've highlighted that and put a red ring around it just to make sure that I highlighted it to your lordships.
I mean, there is one circumstance, possibly at least one, in which you would register a claim or complaint with the FSA, and that's when the FSA exercises its statutory power to bring collective actions. And that would invariably be accompanied, either before, but quite commonly also afterwards, with people registering the right to rely on whatever the result of the collective action is.
I largely accept that point, my lord. I'm not, and I don't have it to hand, I'm afraid, I'm not convinced from my own researches that that's the exact language.
No, it's not the exact language.
That the rules use. And so it may be in
There is
broad
a provision for collective claims.
There is.
Which this is litigation brought by the FSA on behalf of sometimes named parties, a very large number set out in a schedule, and sometimes a category not identified by name, but identified by a process of registration.
And that would be a particular, one can see in that context, there may be a particular reason why you may wish to make, for the avoidance of doubt, it very clear that compendiously that this was included within the first limit. I don't place all the weight of my case on that, but one can see how a draftsman, in a clause that's not perfectly drafted, I have to concede that, may have thought that that was something that could be achieved. If I may go on to my next point from a linguistic perspective, that is that it's somewhat surprising that on my learned friend's interpretation, what's covered by the clause are all actions, proceedings, losses, claims, following and arising out of claims.
Yes, I see.
It's particularly surprising in my submission that 3 of the first 4 things that are specified in the clause in Lim 1, actions, proceedings, I skip over losses and go to claims, should give rise to that tautology. If, as my learned friend says, Part A was intended to be the condition that applied to everything that went before. And in my submission, that tells fairly strongly against my learned friend's preferred interpretation of the Court of Appeal's interpretation.
But you've also got the linguistic point that claims in 1 is particularly odd in light of claims in what Lord Justice Christopher Clark calls A.
Indeed, my lord. Indeed, my lord.
Trouble with all this, one can't help feeling that 1 was dredged out of some provision in some other incarnation, which for some unaccountable reason always seems to include not only liabilities, let's say losses, damages and so on, but also claims, which are none of those things. There are any claims.
And I may say, my lord, that could
that's all. You see that all the time, don't you?
And I may say that could be indicative of how wide-ranging they wanted this clause to be, although no doubt my learned friend could say something different. And that's why, for good reason, on the basis of Prenn and Simmons, we're not allowed to put in evidence as to how the clause evolved or how the negotiations took place in order to aid with this process of interpretation.
Yes.
The final point that I wanted to make in relation to the linguistic aspect of the clause is simply this. The clause doesn't say who has to have been doing the mis-selling or suspected mis-selling of any insurance or insurance-related product or service. That is the case on both my interpretation and my learned friend's interpretation.
Yep.
In my submission, however, it's plain from the context in which the clause appears and from the broader context that what is being talked about is the mis-selling or suspected mis-selling of the company. The SPA is concerned with the sale of the company and the condition of the company upon completion. The clause is located in the section dealing with warranties that are addressed to the state of the company upon completion. All the warranties that are in Schedule 4 are focused, well, not all, that's not quite right, but the general scheme of the warranties in Schedule 4 is focused on the condition of the company. And Clause 711 itself, the immediately preceding words, are focused on the period prior to the completion date. And it's only in the context of the company that the completion date is, in my submission, significant. And otherwise, I say it's overwhelmingly commonsensical that, given the general scheme of the contract, what this is talking about is mis-selling or suspected mis-selling by the company. Turning then to my final area of submissions, unless we are to go back to the law during the course of this, and that is the question of commercial considerations. I wish to address commercial considerations from 2 perspectives. They're distinct, but they are, in my submission, also somewhat related. First, I plan to address the likelihood...
Could I just pick you up on that last point? I mean, if it's simply mis-selling by the company, why do we have the wide definition of relevant person to cover a dependent of an employee or former employee?
The wide definition of relevant person is, to be absolutely honest, difficult to fathom. It's difficult to fathom on my case, and it's difficult to fathom for my learned friend as well. It's a very curious thing to have included. It's curious to see how a claim against a dependent of a former employee could conceivably give rise to anything that, on any view, could be covered by anything else in the clause.
But your approach saying this is obviously relating to mis-selling by the company has to airbrush out the offending definition of relevant person.
I don't accept that, my lord.
Why not?
Because all that 2 and A read together are doing is, as I say previously, trying to make clear for the avoidance of doubt that those things are covered by the first section. On my submission, even if there is a claim registered with or a complaint registered with the FSA against a dependent of a former employee.
But I mean, complaints can't be registered with the FSA, as you've said, but they...
Indeed, a complaint then, my lord. If a complaint is made
against a former employee.
Against a former employee or a dependent, it's only if that complaint relates to mis-selling, or it's only if the loss, the fine, compensation or remedial action or payment relates to mis-selling or suspected mis-selling by the company that liability is triggered under the clause. Otherwise, it would lead to a bizarre situation whereby a dependent of a former employee could have worked for another company and somehow that led to some wide-ranging investigation and some other company in Capita's group comes along and says, well, we want to claim because a dependent of a former employee has had this complaint made against him and it's caused us problems.
I mean, I know what dependent means. Is it a mistake for personal representatives, do you think? I.e. following the death of a former employee or an employee. But I mean, isn't it conceivable you could have a claim or a complaint to the FSA which says this person, and the company might be saying, well, he was acting outside the scope of his employment and so on, and nonetheless it would be a complaint the FSA could investigate and they could conclude that the complaint against this person should be regarded as involving the company's liability. Similarly with the sellers, they're obviously, as the claim would be against them on the basis that they were directors, and the FSA might say yes, and as directors the company answers. Well, isn't that all? I'm not sure why it makes, I mean, it obviously shows a concern to be wide, but does it go beyond good sense?
I struggle to see how it does, my lord.
I mean, I can't possibly, as you say, embrace a sort of activity for on behalf of different people entirely, different concerns entirely that you were talking about.
Indeed, and one must also note that there has to be a payment to the buyer to indemnify of an amount equal to what would indemnify the buyer and each member of the buyer's group. So that's any company in the Capita group of companies. Yeah. And if there's not that restriction of it's got to be mis-selling by the company.
Yes, how would they need indemnity? Yeah.
Indeed. Or rather, it's a staggeringly wide indemnity, which in my submission it's clearly not intended to give here.
Yes, I'm right, am I not, in thinking that the rules made under the Act contain provisions making regulated companies effectively strictly liable for the default of their employees or self-employed agents on a basis much stricter than the common law of vicarious liability?
I think your lordship's right. I would want to check that over the...
Well, that wouldn't explain the inclusion of dependents, but it might explain why, at least in part, the definition was thought relevant in this context.
I will give further consideration to that, if I may, with access to the actual rules, if I can get it over the adjournment. If I may move back then to the commercial considerations.
Yep.
I first would like to address them from the context, from the perspective of the commercial context in which the SPA was concluded, and which construction in my submission makes more common sense in light of that. And then I'd like to, and I approach this aspect a little more delicately, I would like to address the objective purpose of the clause, and that is the purpose of the clause as ascertained from the contract itself and from the broader context in which it appears. And I've teed up, I hope, that submission by what I've said already about the various provisions of the SPA.
Yep.
On the commercial context, as your lordships would have read, I say that one has to have regard to the particular nature of regulation by the FSA, and also the likelihood that substantial liabilities in respect of mis-selling would result from intervention by the FSA or from self-reporting, rather than from specific claims or complaints from customers.
Well, that's a point that cuts both ways, isn't it? It's both a reason why Capita would want it included, and a reason why Mr. Wood and his colleagues would want it excluded. FSA interventions have a vastly bigger financial implication than complaints from customers, because they effectively generate complaints in the whole affected population.
But the provisions of the clause aren't just isolated, my lord, to indemnity in respect of complaints from customers. It goes much wider than that. All losses on my learned friend's construction following and arising out of complaints about the company to the FSA. And so one person could make a complaint, and that could lead to the FSA coming in and forcing a wider remediation scheme on the company. And on my learned friend's submission, that would be recoverable. So the point I want to illustrate, and I'll do it by reference to a couple of examples in a moment, is that it's inherently unlikely that the mere fact of whether there was a claim or complaint before any of these categories of losses arose is inherently unlikely.
Yep.
I would also make the broader point that one has to be, in my submission, and this does trespass a little on the law, a little careful about too readily looking at it and saying, well, one party may have wanted this, one party may not have wanted it. Because it's possible, if one takes that approach, to effectively define oneself out of considering what the more likely commercial common sense construction is at all. Because one can always say, well, okay, it may be quite unlikely, but it could be the bargain that the parties alighted upon.
I mean, there may, for the reasons you give, be an oddity about any limitation to liabilities arising out of claims or complaints. But it's an oddity which exists on both parties' construction, isn't it? Because claims or complaints clearly limit something, even if it's only number two.
But if number two is, as I say it is, encompassed completely by part one, it's not limiting anything. It's merely helping describe things that for the avoidance of doubt, and my learned friend accepts that part two is in there for the avoidance of doubt, that for the avoidance of doubt, it's covered by part one. The learned friend makes a lot of the point, which is in my submission wrong, that I effectively accepted at first instance that it was a condition. But a
Well, it
condition
doesn't matter. We're questionable arguing what you say now.
Indeed, but what I say very, very clearly is that it's wrong to be reading following and arising out of as meaning to narrow the clause in any way. What they are doing when read with part 2 and A together, what they are doing is making clear for the avoidance of doubt that those things described compendiously by both parts of the clause are covered by and encompassed by part 1.
Yep.
But both parts of the clause means there what? Those things described compendiously by both?
By part 2 and part A together.
Yes, I see. Are within the scope, effectively, of the clause, and it's just a... I mean, you say it's just a precautionary...
Exactly.
Would you say its effect is to make sure that these things are included rather than excluded?
Exactly, my lord.
I mean, even if it's, whether you regard it as an explanation or a limitation, may not matter. The explanation would tell us what sort of things were included.
Some sorts of things that are included. And in my submission it does
claims
that.
or complaints, and that may not have been a sensible thing to do, but it seems to be what they have done. I mean, that is the description that the parties have attached to the category of liabilities that they intend to be included.
With the avoidance of doubt, yes.
You would like to write and without limitation in?
Well, I obviously don't need to, my lord, but if it said that, I'd be much happier. And in my submission, if it said that, you wouldn't be doing harm to what was intended by the party.
You said there is no limitation, therefore that's the effect of how you read it. Okay. Yep.
I mean, the difficulty is that, the one my lord's pointing out, if the drafter felt it was appropriate to make this clear, unfortunately the drafter obviously didn't have in mind the full breadth of the risks involved in relation to the FSA, because otherwise it's inconceivable he would have used the words following and arising out of claims or complaints. He would have said following or arising out of claims or complaints or ex proprio motu intervention, the intervention of their own motion.
Yes, my lord. Yes, my lord.
Yeah.
Yep.
If I may turn to my examples then. Say a customer writes to the company querying the premium that it paid
Yep.
for a policy purchased prior to the takeover,
Yep.
at a point in time when no claim is possible under the warranties. The company investigates the circumstances of the sale. The company identifies that the policy was missold.
Yep.
The company entirely properly and in accordance with its regulatory obligations decides to reimburse the customer. So it has to treat customers properly and fairly.
Yep.
Under the principles. On Mr. Wood's interpretation, there will be no liability under Clause 711, as there will be no claim or complaint registered with the FSA or other similar authority. If, however, the company were in a flagrant breach of its regulatory obligations to ignore the customer's letter, such that the customer was forced to issue a claim, then on my learned friend's construction, liability would be triggered under Clause 711.
Would the customer's letter not constitute a complaint?
My learned friend nods. I'm pretty sure that the issues of the particular complaint in this case that we're concerned with, and I don't want to go into that, he says are not enough to constitute a claim or a complaint. And so there's a desire there to construe it narrowly. It's very easy to say, oh, yes, it would now. But on my submission, it wouldn't, unless you adopt such a wide meaning of claim or complaint that what is said to be a condition becomes effectively meaningless.
Just to remind me, what sort of letter are we talking about hypothetically here?
A letter, or it could even be a telephone call, hypothetically saying, I've looked at this premium that I paid a few years ago for this insurance policy. It looks a bit high given what I've been paying since. Can you let me know how it was calculated? And we look into it. We find out there was mis-selling.
Yeah.
We ought to write to them saying, you were mis-sold, here's the difference. But we can't do that. On that scenario, there wouldn't realistically have been something that could constitute a complaint, and we wouldn't be able to recover under the clause. But if we did nothing, or forced them into issuing a claim perhaps, then there would be liability.
Because there'd have been no claim, or if you paid out properly, as you should have done, there would have been nothing registered with the FSA. End of story.
Indeed, yes, my lord. Yes,
And understand. Okay, that's short point. Understood.
To take another example, suppose the management of the company...
If that example occurred and you identified mis-selling, would you be in breach of your obligations to the FSA simply to reimburse the customer and not tell the FSA?
In my submission, not. I'm not saying that we wouldn't also have to tell the FSA. I have to be honest, I'm not sure about the precise detail of the reporting report.
Well, I just wonder how realistic that first example is, given the nature of the duties to the FSA that you were emphasising earlier. Would, and I think it's important to that example, would the company have to tell the FSA that they'd compensated for mis-selling? An individual, because the FSA might want to think, well, if they've mis-sold to A, you might have mis-sold to B, C, D, and E, and many others.
My suspicion on my feet is that as part of these arrow visits that take place, they would have to disclose that to the FSA, because it's exactly the sort of thing they're interested in, what's been happening.
Yeah.
So a claim or complaint could therefore perhaps, on one view, be said to be registered with the FSA if, as a result of the company receiving the claim or complaint from a third party, the company was obliged to inform the FSA.
Well, what happened in this case is that the FSA was informed about the mis-selling that took place on Mr. Wood's watch, or mis-selling we say took place on Mr. Wood's watch. And my learned friend's very case is that doing it yourself does not amount to something that's within the clause.
If the fact that you register it with the FSA brings it within the clause, it's a bit odd that Capita can, as it were, choose whether or not to bring a claim within the clause by registering it with the FSA itself. If it's registered with the FSA because Capita registers it, rather than the complainant.
But I thought you were saying that there would be an obligation to register it. That would be the objective criteria, and it wouldn't be a matter of choice.
Well, that depends what one means by registration.
Exactly.
Yes, exactly.
I mean, that's why I think that registration is actually concerned with the collective litigation provisions of the Act.
But on both analyses, if that's right, and even if it isn't, it's a very unlikely distinction to have given the prominence that the Court of Appeal and Learned Friend give to it in this clause. It's the linchpin around which the rest of the clause rotates.
Well, it's obviously an issue you may be fighting out in due course, and it may be there's some background in the FSA rules which would help us as to what the word registered means.
I'm not sure that there is, my lord. I've been unable to find anything.
Well, but 2 talks about imposed on or required to be made. 1 refers to there's no such, it's suffered or incurred, so presumably 1 may include a settlement payment, whereas 2 may not.
What?
I'm looking at 1 and 2 simply on the basis of the break-up of the clause by the Court of Appeal.
It would, my lord, unless A has the role that the Court of Appeal and my friend give it. And that's what I say is commercially not commonsensical.
I mean, if you get a claim, if Capita receives a claim based on a pre-sale transaction, which Capita thinks is entirely misconceived, does Capita have to report that to the FSA?
I'm not in a position, standing here now, to answer that without risking misleading you, my lord.
Depends on the reasonableness, objectively, of their view that it was misconceived. The reporting obligations depend on, don't they, on whether a report would have been made by somebody who was a hypothetical manager who was competently performing the various obligations under the rules.
And it may be as well, report isn't always necessarily a term of art. It may be it's something that they would...
Is registered a term of art?
Yeah, registered.
My submission, no, my lord.
Well, exactly. But I'm thinking if they get a claim they think is misconceived and simply put it on one side, and the person then goes to the FSA, and the FSA think it's justified, then on the case again, on both of you would agree it's within 711.
I think I certainly would, and I suspect my friend would as well.
If, on the other hand, it's a stronger claim and you think it's justified and paid out, on your case it's similarly covered, whereas on your opponent's it isn't.
Yes, my lord. And of course, what's said here is that the head of loss recovered has to be following and arising out of the claim or complaint registered with the FSA.
I understand that. That's my point.
And so that, of course, limits it down as well, such that if one was to report at the same time as saying, we've got to reimburse this customer, one wouldn't fall within my learned friend's construction of the clause. To take another example, suppose the management of the company were to have discovered, say, last year, that the previous management had, or while the previous management were in place, a serious fraud had been executed against one of the company's customers. The customer wasn't aware of it. Management took the view that they investigate it themselves, they take legal advice, and they take the view that they are obliged to inform the customer of the fraud. The lawyers say that their liability is going to be at least, say, and I'm just plucking a random figure out of the air here, £500,000. You're going to have to be on the hook for that. The company writes to the customer and says, we've discovered this fraud, it's obvious we're liable to you, we'll compensate you, here's £500,000, because it's obvious you'd recover this amount on a claim or by way of compensation. On Mr. Wood's case, there'd be no liability under clause 711. But if the company were to have said to the customer, we've discovered this fraud, it's obvious we're liable to you, but we will only compensate you if you register a complaint with the FSA or commence a claim, then, but only then, liability would be triggered under clause 711. And in my submission, what's the commercial justification, commercial common sense behind that?
See that, yeah. Unless...
And as Lord Reed said in Whitman Machine Tools, the fact a particular construction leads to a very unreasonable result must be a relevant consideration. The more unreasonable the result, the more unlikely it is the parties can have intended it. And if they do intend it, the more necessary it is, we should make that intention abundantly clear. I'm glad I managed to shoehorn in a little bit of law, my lord.
fair enough.
Previously, in order to try to address these points, my learned friend has suggested that the sellers could somehow take a view as to claims or complaints that had taken place prior to the takeover, and therefore it might be a meaningful distinction to allow them to estimate what their liability would be after the takeover. My submission, that's ethereal. There's nothing in it, because it's just as likely that they could have taken a view by reference to remediation they'd been obliged to put in place by the FSA or any other form of mis-selling related loss they'd had to suffer.
If they'd taken a view about it before the completion, it would have had to be included in the disclosure letter, wouldn't it? Which is an exclusion from the warranties.
Yes, I think that's probably right, my lord.
Yes? Right.
So that's all I wanted to say about commercial common sense per se. I wanted also to address briefly the commercial purpose of the clause, assessed objectively. Lord Wilberforce said in Reardon-Smith line, and I think this is hopefully my last reference to any of the case law, when one's speaking of the aim or object or commercial purpose, one is speaking objectively of what reasonable persons would have in mind in the situation of the parties, and that's at 996F in Reardon-Smith line. As I've probably done to death already, the sellers had control of the company beforehand, the buyers didn't have the insight. And to make sense in light of that, for the contract to allocate the risk of mis-selling prior to the takeover to the sellers and away from the buyers. And that is a purpose that, in my submission, can be objectively ascertained from the terms of the SPA itself. As we've seen, clause 711 appears in the section that's headed warranties and indemnities. So the warranties and the indemnities are thus connected. And as I emphasised when we were looking briefly at Schedule 4 and the terms of the warranties in Part 14 of Schedule 4 and in paragraphs 12.4 and 12.5 are extraordinarily wide-ranging and exhaustive. Their clear purpose in my submission is to protect Capita in the event that the company is not in the condition that it's expected to be. And that, together with clause 711, which, as I said earlier, goes beyond the warranties, shows that in respect of mis-selling or suspected mis-selling, risk is to be allocated away from Capita and to the sellers. I also emphasise that clause 711 is, in every other respect, apart from the one passing issue that we're arguing over, expansive. So it says the sellers, the indemnity effectively extends to the buyer and each member of the buyer's group. So that's every company in the Capita group. And that's protecting, in my submission, against Capita getting collateral damage from mis-selling that's been conducted prior to the takeover. It refers to all actions, proceedings, losses, claims, etc. It refers to all fines, compensation, etc. The losses that are covered are said to be pertaining to any mis-selling or suspected mis-selling, and I'd emphasise also suspected mis-selling. That, again, goes a long way. And in my submission, that says that to the extent the language will bear it, one should strive to interpret the clause as giving meaningful, wider-ranging protection rather than narrower, arbitrary.
But like most arguments, this cuts both ways. Given that there's so much in favour of one party, there might expect to be a compensating reduction in liability to satisfy the other party. I mean, that's an equally valid argument as yours, isn't it?
In my submission, there is so much that points to the general allocation of risk in this contract that can overcome, at least to a certain degree, the point that my Lord's making.
Fair enough, thank you.
But there's another form of the same point, isn't there? Which is that if there's a very large and discrete source of financial risk, such as an FSA-instigated mis-selling investigation normally involves, that might provide a good reason why it should have been intended to be subject to paragraph 14.1 of Schedule 4, and therefore the 2-year time limit in Schedule 5, as opposed to being imposed without time limit under 711.
That sits in my submission somewhat unsatisfactorily with the way Clause 711 reads. It is very expansive at the beginning, all losses, and then it's losses pertaining to mis-selling.
Slightly odd, isn't it? I mean, it may be necessary, but it's slightly odd to read 711 as having so expansive a meaning that it essentially deprives of effect the time limit that would apply to paragraph 14.1 claims under the warranty schedule.
Well, only in respect of mis-selling.
Exactly.
I mean, it clearly does it in respect of something.
Yeah.
And the
My
question
Lord took
is,
the words out of my mouth.
how much?
Yep.
So, in summary, unless I can assist your lordships further, I say the law is clear. Where there is a contract that's open to more than one interpretation, And here I should emphasise the Court of Appeal at paragraph 28.3 found that the words of this contract could bear more than one meaning. One should choose the interpretation that's more consistent with business common sense. I say the words of clause 711 are more than capable of having two meanings. Contrary to the Court of Appeal's view, however, Capita's interpretation is more likely from an analysis of the language, the grammar, and the syntax of the clause. And then I say when one has regard to commercial common sense, the choice between the two interpretations becomes even clearer. And unless behind me there's anything else that I should address at this stage, those are my submissions.
Thank you very much indeed. Thank you. Mr. Twigger.
My Lord. May I start with commercial common sense? I heard what your Lordship said about the law, and I'm not going to take you to lots of cases, but...
Or any, I hope.
In my submission, it is worth thinking about the kinds of case in which commercial common sense has featured as an important factor or determinant of the meaning of the clause. And sometimes the expression commercial common sense gets used just as a contrast to over-pernickety or over-literal interpretation. I think we can leave that one to one side.
Yeah.
But in the vast majority of the cases actually in the bundle, and certainly the ones that have got as far as your Lordships, what seems to be the case is there are two features. First of all, you can tell what the commercial purpose of the clause or the contract is with reasonable certainty. And the second is that one interpretation fits with that commercial purpose, and the other interpretation really doesn't seem to have any commercial rationale at all. And when one looks at the cases, that can be said about quite a number of them. Prenen-Simmons, the cases about the rent review clauses, Lord Hoffman's case, and indeed, in my submission, Rainy Sky, too, is one of those kind of cases where one could see that the purpose of the bonds was to cover the buyers of the ships in case the advance payments weren't repaid. And in those circumstances, it wasn't any very obvious reason why that wouldn't work in a case of insolvency. And the bank couldn't suggest any reason. I think in my Lord Clark's judgment, that's one of the factors on which you rely. So one gets, in these cases, a clear indication of what the purpose is and that one construction fits with it and the other one doesn't. In my submission, there's another class of case, and the case before you now is in that category, where one can say that the purpose of the clause is to allocate risk, one way or other, undoubtedly right. But the whole point is that the parties have been negotiating about the way in which that risk is to be allocated. And what one can't do is start from a position where you say, plainly this clause was intended to allocate all of the risk to one party or to the other. And then I construe the clause so that it fits with that intention. In my submission, that's the wrong way round. You have to look at the words of the clause in a case like this in order to decide how the parties had agreed to allocate a risk.
So your point is ultimately this is clearly an allocation of risk, where the risk is not meant to be completely allocated one way or the other, and therefore we're not going to get much help by looking at the commercial purpose in broad terms. We have to look at how they've allocated it by reference to the words they've used.
Exactly.
Yes, I see.
Exactly. And so when my learned friend says things like it's arbitrary and uncommercial to restrict liability to where there have been claims or complaints, I would say, well, that's what the parties were agreeing. He says it's a compendious description, is the way he puts the purpose of that bit of the clause. But then if it's a compendious description, and if what you're trying to do is to make clear that it's all liabilities for mis-selling that are transferred onto or remain with the sellers, why refer to claims and complaints at all? Surely what you're doing there is not putting in a clause for the avoidance of doubt, but you're creating doubt, because you're pointing to a set of circumstances which, on my learned friend's case, it's not limited to. Now, Malone Friend says that there's no commercial rationale behind my construction. For the reasons I've explained, it's quite difficult to look at commercial purpose in this context because it's a negotiation for the allocation of risks. But in my submission, the warranties are very important here, and that's what the Court of Appeal focused on. Malone Friend has shown you some of the warranties, and you've seen that there's a very long schedule, very lengthy schedule.
Yes.
And it was a very elaborate, carefully thought through mechanism.
Yes.
But with the 2-year backstop.
Yes.
And so Malone Friend's point, which starts off being a fair point, which is that Capita is the buyer and doesn't know how the business has been run and has no way of investigating, query whether it would have done due diligence and so on, and I don't think we have any evidence one way or the other in this case. But what it does have is that 2-year warranty period to go in and investigate. And indeed, in this case, we know that it did do that, and it did discover the allegations on which it now bases its claim within that 2-year period. What the parties, and so the parties have obviously agreed that after 2 years, you've had your time to look into this company, and time's up at that point. You have to notify the claim, and then I think you get another 9 months to issue your claim, your legal claim, in the usual way. But what the parties couldn't do, they could agree that, but they couldn't agree that third parties wouldn't come along at a later point, up to 6 years, or maybe even longer if there's fraud involved or concealment, and bring a claim. And so in my submission, that's what this indemnity was designed to deal with. That possibility that somebody would come along after the 2-year period was up, out of the blue, and say, I've got a claim against you, and they would have to be compensated. And that fits, in my submission, with the idea that the indemnity covers suspected mis-selling, because the addition of suspected mis-selling at the end seems rather odd and rather broad. But if one thinks of it in terms of potentially a third party coming along and making a claim, they may make all kinds of allegations which it may or may not be possible to see whether they can be made out at an early stage. Capita company may say, fine, we see that, we'll settle that claim or whatever. And that would be on the basis of suspected mis-selling without the mis-selling having been proved. In that context, it makes sense to talk about suspected mis-selling. But if you're going to have an indemnity that covers something so broad as suspected mis-selling, you would naturally be wanting to limit it. You wouldn't be saying any kind of mis-selling anywhere, whether there's a claim or complaint or not.
Why not? Why wouldn't you want to cover a whistleblower going to the FSA down the line and saying, look, nobody knows about it, but while I was in this company or involved with it, this was going on, and the FSA then intervening. I didn't see why.
Yes, your Lordship's quite right. Capita would want to cover those possibilities, but one could say as part of the negotiation, Mr. Wood would be saying, I'm not prepared to cover that kind of
but it's just a bit of an odd, I think the argument is it's a bit of an odd distinction. Why should they focus just on third-party claims? On the other hand, you can say, well, that's what the wording says.
Well, that really, that probably is the short point in this case, and that is what the wording says.
And in that context, what do you say registration with the FSA involves?
Well, registration's rather odd.
Registration on the face of it is a formal step, which one would expect to correspond with some identifiable procedure.
Yes, my lord, but I agree with my learned friend, at least about this much, that it is very difficult when you look at the FSA rules. And indeed, of course, it talks about registered with the FSA, the Financial Service Ombudsman, or any other authority. So it seems to be broader than that. And when one looks at the rules, there is no obvious process of registration. And I wondered whether, I'm not sure whether one's allowed to rely on the authority of Monty Python, but I was reminded of the parrot sketch where the gentleman comes in and says, I wish to register a complaint. And I wondered whether it's just being used in that sort of colloquial sense, that somebody is thought of as registering a complaint. It just means I'm making it, rather than there being anything technical about it. But I do accept that it's an unusual word to have used in that context. Shall I move on to the construction points? Because in my submission, there really are only, I think, 4 main points that I want to make.
Thank you.
The first point is the point that Lord Justice Clarke makes in his judgment, which is that when you sit down and read the clause through, it breaks down naturally, just as a reader, and of course these things are always slightly a matter of impression, so it may not break down in the same way for everyone, but it breaks down really into 2 lists of potential liabilities that are being covered, and then, in fact, 3 conditions that apply to it, because what we all call B at the end breaks down really into 2 things. It's relating to the period prior to the completion date. That's the first. And then the second is pertaining to any mis-selling or suspected mis-selling.
Yes, I see.
So
if one wants to refine further, one's got B alpha and B beta or whatever.
Indeed.
Yeah, okay.
Or you
Thank
could
you.
call it B and C. Or, and of course, we just haven't broken that last bit down because everybody accepts that everything within B applies to any liability, however it may arise. And my point arising out of that is that if that's the right reading, so that what you've got there is 2 lists and 3 qualifications, then it is inherently more likely, more natural, that the 3 qualifications, the following and arising out of claims, and which relate to the period prior to completion, and pertaining to any mis-selling, apply to all of the liabilities in both lists, rather than the first of them applying just to the second list. And that was my point about the
I don't follow that. I mean, that's a matter of impression, and but I don't see why it's inherently more likely.
It's simply a point about just normal use of English.
Your point is, and one remembers, even though it was a long time ago now, making this submission in your position, that this is how it strikes you. And the answer is, if the judge says it doesn't,
well, then it's
nowhere to go. Yeah.
I mean, I do see.
It's a perfectly fair point. I'm not meaning it's not. But
No, I understand. But that was my point about the cats and dogs which are black and fluffy, which is the Court of Appeal.
We are.
But it was just a point that it's odd where you've got A and B are X and Y to say that the 2 middle 2 go together and the 2 outside ones go together. It's just not a very natural use of English.
okay.
So that's the first point. The second point is the point that I think my Lord Sumption made at one stage in Malone and Friends submissions, which is that if Malone and Friend is right, then really the whole of what we call 2 and A are completely OTOs. So, that can be illustrated by the facts of this case. This is a case in which what is said is that remedial action or payments or compensation have been imposed on the company by the FSA. So it's the kind of thing that just reading the clause, one would naturally think falls within 2 and A. But then my argument is going to be, well, there weren't any claims or complaints. And so Malone and Friends' case is, well, that doesn't matter because we fall within 1. Actions, proceedings, losses, claims, etc. And you just ignore 2 and A altogether.
So in your case, 2 is unnecessary as well. Because,
Well,
I mean, it's quite obvious that if 1 and A are linked, then 1 will cover fines, compensations, remedial action, or payments, because it will fall within the words actions, proceedings, losses, claims, damages, costs, charges, expenses, and liabilities suffered or incurred. So on your case, 2 is unnecessary, whereas on you say that on the appellant's case, 2 and A are unnecessary.
Well, I suppose you could say that fines doesn't obviously come within one.
Well, I was going to say, my Lord, there are really two points in response to...
Losses.
Losses?
Well, the first point I was going to make is this. The word liabilities is the one I was going to focus on in 1. Liabilities is about as broad a category as one can really imagine.
Well, it's pretty obvious that there's a considerable amount of repetition here.
Yes.
Or overlap.
However one looks at it. And this is what I think my Lord Newberg has referred to some as the torrential drafting. I think you may have...
That was actually Lord Hoffman's statement. I cribbed it from him.
Yes, so both 2 and A on Capita's approach are unnecessary, but your point presumably is that A on that approach may be unnecessary, but it's not. It is also words of limitation. So
that was going to be my second point.
Why on earth state them? Yes.
So that the first point is that there is a bit of a distinction between 2 and 1, in that 2 is looking at payments and things that are imposed on the company by someone else, whereas the first one is looking at actions, proceedings, losses, etc., etc. But I agree, it is difficult to see, but you could say you don't really need any word other than liability, or possibly losses and liability. So plainly, the draftsman was just including a whole load of things to avoid any argument later, avoid somebody coming to your lordship's house and saying, this isn't fines and...
Been very successful.
Well, indeed. Okay. Whereas, as Lord Hodge has pointed out, the point about the words in A is, in my submission, that they are clearly the kind of words that you would expect to be used as a form of limitation of the indemnity. They are the kind of words that tell you what the causal link has to be before the indemnity is triggered, following and arising out of claims or complaints. Following and arising out of, certainly arising out of, I think is a word frequent, or expression frequently used in insurance contexts to trigger the cover. So in my submission, it would be surprising to have used those kind of words in A if you didn't intend them to have any effect at all, because you could just ignore them and rely on wording in 1.
It's actually claims or complaints registered with the FSA, which are the words of limitation, because I think arising out of has been defined as widely as it can conceivably be in most commercial contexts.
Yes, but it's showing that there is a link between the losses and whatever it is, and in this case...
Yes, and it follows from that, if A is if A involves words of limitation, it has that characteristic in common with what you're calling B1 and B2.
Yes, exactly. And the point about that is, it's a point that has been debated in the courts below, but of course, A starts with a participle following and arising out of, B starts with and which, but then B2, or whatever we're calling it, starts with pertaining to another participle. So plainly, the draftsman hasn't been very consistent, whichever way one looks at it. But the fact that he uses the participle with pertaining in B shows that there's nothing particularly surprising. There's no real difference with following and arising out of at the beginning of A. So I say the reasonable business person reading this agreement would read
because they cribbed them from 2 different documents.
Well, I'm sure that's absolutely right. And I mean, what I would say, your lordships have seen, my learned friend took you to the other indemnity in 712 about the employment contract with a gentleman whose name I've forgotten. But of course, that starts, lordships, that was on page 194. But that starts with exactly the same words as this clause starts with, shall indemnify the buyer and each member of the buyer's group against all actions, proceedings, losses. So it looks like that wording is part of this draftsman's sort of precedent. That's what that's his indemnity wording that he just takes out of his cuts and pastes from his standard form document.
So the serious bit is 2, you say? Or it tends,
Beg your pardon, my lord?
it tends to suggest, you say, that the serious bit where he was really focusing his mind, was actually 2.
Yes, and it's also an important point to deal with Malone and Friend's point about claims arising out of claims. His point he makes the point
Yes.
it's tautologous or it's odd to talk about
That's
claims
quite a good
arising
point,
out of
isn't
claims. In my submission, that just arises because he's using this general wording at the beginning, proceedings, losses, claims, damages, etc. And then it fits rather oddly with what's gone later, but he hasn't really focused on the grammatical problem there.
Yes.
So I was trying to remember how we got to that point, but I was making the point, which I think was my second main point.
It was.
That 2 and A on Malone and Friends construction are completely OTOs.
Yes.
And particularly A is OTOs, and it's not something that you would expect to be OTOs when you read it, because they are words that appear to have a function. And my third point really follows on as a similar point, which is that the words at the end of A, against the company, the sellers, or any relevant person,
Yes.
are also important words. And the parties must have included those because they wanted to indicate who it was. Malone and Friend made this point that there's nothing in the clause which says who's had to do the mis-selling. Mm-hmm. But in my submission, that's not quite right. This is talking about claims or complaints against the company, the sellers, or any relevant person. Yeah. And so in one way, that's words of limitation, but in another way, it's words of expansion, because it talks about not just the company, but also the sellers and the relevant person. Can I just, while I think of it, explain the point about the relevant person,
yes,
which I agree is rather odd. I think the real reason for that definition is because of the pension arrangement.
It's elsewhere in the yep, I agree.
Which is on page 225.
Yep.
And just to show you this, I mean, this is a small point, but perhaps worth bearing in mind. In page 225, the warrant is dealing with pension arrangements. Yep. Paragraph 7.4 does make a distinction between no relevant person has made or threatened any claim other than a routine claim for benefits, or a complaint, including a complaint to the party's ombudsman. So that does show that at least the draftsman did have in mind the distinction that I make.
So it's probably some sort of, as Lord Mance suggested, some sort of personal representative sweep-up type of thought.
What I wondered, and this is of course pure speculation,
yes,
but is that if you'd said claims against the company, the sellers, or any employee, employees were defined in the agreement
right
as the employees at the time right of the agreement.
Whereas relevant person includes a former employee.
Yes.
I see.
And I think maybe that was the thought, not the dependents.
I see.
So to include the former employees within the clause, right?
As I say, that's
so basically it cast its net too wide, but did include a necessary class of persons.
Yes.
But dependents, couldn't they
well,
complain about mis-selling of pensions? If they were the recipients, your widow is a recipient of your pension, she might well have a mis-selling claim, might she not?
Yeah, but these are claims against.
Yes,
not claims by.
Yeah, this company is selling
claims against costs. Yeah, I'm going right.
Yeah.
Well, anyway, this
selling car insurance, so it's quite difficult to see how you might really get a dependent making a claim.
I think probably this point is not likely. It doesn't really bear on the issue, but thank you for that explanation. Coming back to your point, though,
but yes,
the final words of clause, what we've called A. Why does that help you?
Because those words against the company, the sellers, or any relevant person, if they are going to apply, let me start that again. If the parties were wanting to make clear that this indemnity was dealing with claims against the company, the sellers, or any relevant person, then they wanted that to apply both to the list of liabilities in 1 and the list of liabilities in 2. They surely were not intending to limit just the list in 2.
Thank you.
If that's right,
Yes, then the rest of...
then A must apply to both.
You can't pick and choose,
Yes,
take part of it.
exactly.
Yes, I see. Yes, thank you.
And then my 4th point, which I accept is a smaller point, just turns on the word "and" at the beginning of what we're calling B, the "and" which relate to the period prior to the completion date.
Yes.
Because in my submission, when you read that, it suggests that there must have been a prior condition of some sort. It's losses which X and which Y.
Yes, this is the point that found favour with Lord Justice Christopher Clark.
It was one of the points that
Yes, one of several. Yes,
he focused on. Yes.
it is. You're referring to that point.
But there must be something that it's referring back to. Now, you can, as a matter of grammatical ingenuity, read it in various ways that perhaps mean that it still makes sense if it doesn't do that. And that's why I say it's perhaps not the biggest point. I think what my learned friend would say is you can read it, all actions, proceedings, losses, claims, damages, costs, charges, expenses and liabilities suffered or incurred, and which relate to the period.
I mean, it seems to me this is fairly neutral, isn't it?
Well, I would say that only really works because of the words suffered or incurred. If you took those out, charges, expenses and liabilities and which, it wouldn't really make sense. And if you accept my point that and which is referring back to a previous condition of liability, suffered or incurred isn't really a condition.
It is. It's something you must suffer or incur one of the previous things in one.
Well, maybe, my lord. Yeah, I see your lordship's point. And as I say, I don't... Yeah. I'm not putting this at the top of my list for obvious.
You're putting it 4th.
I put it in number 4, indeed.
Yep.
But in my submission, it's a point.
And which is the next?
Those are the 4 points.
Right.
And really all that remains is just to deal with my learned friend's points. His point about the overlap, this is the point that found favour with the judge at first instance.
Yes.
The overlap between 2 and A. But of course that slightly depends on how one reads it anyway, because if I'm right, you separate claims, in fact, you put a comma after claims following and arising out of claims,
Yes.
or complaints registered with the FSA, then A is not relating to regulatory flavoured matters at all anyway. So in my submission, there's really a limit. It's quite an ingenious argument, but it doesn't really work. And also, if one looks at the wording in 2, remedial action or payments, and payments isn't necessarily a regulatory expression, nor necessarily is compensation. So that's that point. The second point is the comma.
We've each got a comma point.
We've each got a comma. I mean, one can debate the commas uphill and down, but the one point that one can make, which I think Lord Justice Clark makes in his judgment, is that the commas are not really used very consistently,
No.
either in this clause or in the agreement as a whole. And therefore, it's very difficult to read very much into the placing of the comma. I think Lord Justice Clark said in argument that he used the expression, the draftsman has so encumbered this clause with material, which I quite liked that as an expression, but it's right in my submission. There's lots in the clause going on.
What about the and all between 1 and 2? It suggests a sort of slight caesura. All actions, proceedings, losses, claims, damages, costs, charges, expenses, and liabilities suffered or incurred, and all fines.
Yes. Well, my lord, I suppose that works on either case, because I do say that 2 is a separate list of other liabilities.
Yes, I see.
And we had the debate about whether it really expands 1
Yes.
at all. But
You say that's consistent with either given. Thank
yes. And one can rely on the absence of a comma, for example, before the word pertaining in B. One could go on forever, really, saying, well, there's a comma missing.
Well, but the significant point is that from your point of view, there's no comma after or any relevant person, which suggests that A and B are connected, whereas on the case against you, there's a big break there.
Yes, but on your case, there ought to be a comma after company.
Yeah, that's why commas are cut both ways.
And which, it can be argued, is the nearest equivalent to a comma, because it, again, suggests
That's
breath.
my friend's case, yes. Well, of course, as one of your lordships put to me earlier, it all depends how you sort of read these things when you first look at them. But I accept all of those points. It can be looked at in lots of different ways. So that's the comma. Claims arising out of claims, I think I've already touched on. It's in my submission, it's inelegant, but it doesn't undermine the point, which is that you just had a standard form list, as it were.
Yes, I see.
And the wording in A was the condition that was being imposed. My lords, unless I can help you further, that's all I wanted to say.
Thank you very much indeed.
I hope I may be mercifully brief, my lords. I think I have 4 points. The first is my learned friend's prefatory comments about commercial purpose conflated my 2 points on commerciality. One is what makes commercial common sense by reference to possible outcomes of different constructions of the clause, which I know my learned friend didn't address. And then separately, there was my final point on commercial purpose, which, as I said previously, I made more modestly, I think I said, or I may have said delicately. My second point goes to...
Right, so what was the second one? It conflates it with what?
Conflates it with my final point about assessing the commercial purpose of the clause from the other provisions of the SPA and the background context.
Yes.
So looking at the purpose of the clause as distinct from which is most likely
Yes.
for commercial men to have alighted upon.
Yes, so possible consequences
Indeed.
or outcomes
Indeed, my lord.
is material, you say, and not addressed. Yeah.
Indeed, and I won't take your lordships to it, but the distinction is perhaps apparent in Lord Wilberforce's decision in Prennan Simmons
Yes.
at 1389G
Yes.
of the report, which is on MS page 811.
Thank you.
That's 1389G, MS page 811.
Thank you.
My second point goes to whether things are OTOs or not, and whether, on my learned friend's case, Part 2 is OTOs, and it was suggested during argument that on my case, Part 2 and A were OTOs. I don't accept that, because I say that reading Parts 2 and A together gives a particular purpose to having for the avoidance of doubt phrase in there. It's making clear that it's making explicitly clear that within the scope of the indemnity are particular losses of a regulatory flavour of the kind that are specified there.
But the trouble with that, I mean, we touched on this in opening, is that it does also make explicitly clear that the drafter can't have been thinking about the issue which we're now arguing about.
Indeed.
Because otherwise it's really inconceivable that they wouldn't have covered it.
But that's not, with respect, my lord, the test. We have to work out what reasonable men reading it objectively would think it meant. Now, they may well say the drafters didn't have this in mind. I see the potential circularity, and I only push the point so far. But that is my argument, nonetheless. Thirdly, my learned friend said, in relation to whether 2 and A should be read together, he read in Part 2 remedial action separately from payments. Whereas in my submission, the ors either side of remedial action suggests that actually you're talking about remedial actions and remedial payments. It's a small point, but one that I felt was worth making. And then finally, and your lordships will have to forgive me for tiptoeing onto this, but I didn't address it in the Court of Appeal, and it then appeared in the judgment against me. My point on the cats and dogs and on the breaking up of the clause in an artificial way by references to numbers is that you just cannot construe a commercial contract like this, stripping out all of the context, stripping out the content of the words even. It's just an inapt way of doing it, and I addressed that in my written case, which just for your Lordship's notes, if your Lordships will give me a moment. From paragraph 65
Thank you.
on page 48.
Can I ask you this?
Yes, my Lord.
Mr. Twigger made the point that the closing words of what we've called A tie in quite well with 1, because otherwise it doesn't tell you who the actions, proceedings, and so on are against. And therefore A should connect with 1. What do you say about that?
I say that even on the learned friends construction, you don't get told who the claims, the actions, proceedings, and claims in Part 1 have to be against. The actions, proceedings, and claims in Part 1 have to follow and arise out of claims that have been registered with the FSA against the company that said as an irrelevant person.
So
but in a way, that emphasises my point about the clumsiness and tautology of claims arising out of claims.
Thank you.
And so that's why I made the point I do about mis-selling or suspected mis-selling, and who has to have been doing it.
Thank you.
Unless I can assist your Lordships further, that was all I had to say.
Thank you very much. Well, we're very grateful to both counsel for the clear way you've argued your case this morning. The fact that you've managed to do so within a significant shorter time than you indicated is a credit and tribute to both of you. And you've made your points very clearly. They've also been made clearly in your written submissions, your written printed cases, which have enabled us to bypass going to the authorities. Thank you very much indeed. We're grateful to all involved. We will consider our decision and let you know in due course. The court is now adjourned.